thanking every member. The debate in post-lunch session in the Parliament is always a bit difficult because many of the members do give their little input and sometimes participate further. But today, the post-lunch debate actually was very invigorating in that every member who spoke very clearly has gone through the amendments, has understood the spirit with which IBC has been brought into this country, with every member's cooperation. And post-2016, with just about nearing 3 years after the implementation, there has been repeated need to bring in the amendments because the amendments were always brought in as a response to what was developing outside of the Parliament, where industries, where creditors, where courts, all of them were using the IBC to give solutions, but there were greater challenges, newer challenges which were coming up. As a result, the amendments are always brought. This time, I'm glad many of the members have credited the government with coming up speedily for what was developing in the recent past, in the last few months, a situation where we thought the legislative intent of the Act itself was being corroded upon, and therefore we had to respond, and we've come out with these amendments. I'm glad very many members recognize that the response of the government has been in time and speedy, and therefore I would just go over rapidly on what these specific amendments aim to achieve, and also then respond to each of the members' questions, also the suggestions. So the Insolvency and Bankruptcy Code, actually the amendment bill which we are talking about now, seeks to amend 7 sections of the Insolvency and the Bankruptcy Code Act of 2016. I shall keep referring to it as the code. And these sections are 26 of 5, 7, 12, 25A, 30, 31, and 33. And they're largely to remove the ambiguities and to facilitate a smooth conduct of the corporate insolvency resolution process for maximizing the outcomes in line with the preamble of the code. I particularly thank Sri Suresh Prabhu, who metaphorically said we have to give a life to these companies. So was the mention by Sri Ashwini Vaishnav, a member from Orissa, who spoke about the speedy, responsive way in which we are coming back with amendments which shall keep the company alive. Also, Jairam Ramesh referred to it. So it's a response to what was developing, and since specifically some of the members have taken the name of the resolution plan and also the interpretation given by the NCLT in the SR case, where I'm glad the points were literally brought out like nuggets, where the interpretation was trying to treat secured creditors to the operational creditors and treating them at par defeated the purpose and also the spirit of the Act. So with such very serious interpretative problems which were coming up, it was only incumbent on the government to come up with a with such amendments, and amendments actually which are clarificatory in nature. So in order, the intent of the government is to ensure the maximization of value of a corporate debtor as a going concern while simultaneously adhering to strict timelines. The timelines related point, I could hear many of the speakers did raise questions and doubts if actually we can implement them. Actually, can we have these kind of timelines added? And I'm very grateful to Sri Bhupender Yadav, who very correctly pointed out the spirit behind Insolvency and the Bankruptcy Code. In a changing India, post-1991, we've had quite a lot of opening up, quite a lot of economy and issues related to speeding up the economy, bringing in more lubrication into what we want to do. We're all discussed. And in the spirit of that kind of a change which is happening in India, which has gained greater traction of late, in spite of the global headwinds, we needed to bring in that kind of a reform, and it is not going to be as though it is being done exclusive of the courts, and it is certainly not eroding into the courts' domain. I would just want to bring in this particular quote or a couple of paraphrasing of the court's words, which will remove from the minds of any one of us who would suspect that by bringing these kind of timeline-related constraints, are we trying to tread onto the court, or are we trying to impose something on the courts? Not at all. We are not imposing on the court is something which I want to explain to you by using the court's own words. In the Swiss ribbons matter in 2019, the Honorable Supreme Court had observed, and I'm not quoting, I'm using their words, so let there not be misunderstanding. I'm using their words, paraphrasing the words of the court. They said, defaulters' paradise is lost through this IBC. So India can no longer be a defaulter's paradise. So because of the IBC, now it's very clear there has to be a resolution. Even if it leads to a liquidation, defaulters will have to be facing law. So that's been recognized by the Supreme Court. Second, again, on the issue of can we amend such laws even as issues are pending in the court, I'm not saying that the court said it in anticipation that we're going to do something, but I'm only using some of these observations by the court. Economic laws need flexibility and experimentation. This is an observation by the court. And if the courts have said that, why are we hesitating in using the legislative mandate that this House has? Legislative mandate is what we're doing. We are not at cross purposes with the court. It is the legislative mandate. And if we don't use our mandate and leave the space open, after all, nothing is left in a vacuum. Something fills it up. But it's our duty to have the legislation, and therefore we are doing it. And again, the court again had observed in the Swiss ribbons matter, we need to move away from traditional approach. Also an observation of the court. So if you are slightly worried, if by saying, and some of our members did observe, are we trying to do something which is very away from what has been the traditional practice? Well, yes, we may have to experiment. And it is because we started the experiment, even in 2016, repeated amendments which are coming, and I would, with one more observation, I would move over to, in fact, quoting the observation of Jairam Rameshji in his participating in a debate earlier, which he himself recalled, in August 2018, which will explain why we have to come back repeatedly with amendments, because it's such a path-breaking code that we've come up with. Supreme Court again had observed the constitutional, and it upheld the constitutional validity of the code. So if the constitutional validity of the court has been upheld, and well within our jurisdiction, well within the division of power as envisaged in the Constitution, the three pillars are using their own areas, legislative, executive, judiciary, the fourth being the media and the press. Within our legislative or the constitutional area of operation, domain of operation, we are bringing in certain amendments. Only the code itself is absolutely constitutionally valid. So let's not have doubts in our mind saying, are we doing too much? Are we treading into the area of the courts? Are we putting restriction on the courts? No, we are allowed to experiment, aren't we? Because the courts themselves have said it. Let me now just sort of, before I get into the details of what I want to highlight, recall, and I quote, I'm glad that the member whose words I'm quoting is himself here. In the August 2018 debate, Jairam Ramesh had said very clearly, we have the Insolvency and Bankruptcy Code, which we are amending from time to time as we gain experience. Exactly. We are gaining experience. And therefore, we are using every opportunity which has to be in time. This time, we have been speedy, which I'm glad many of the members have conceded, and I'm very grateful for that. But that's the point. We have to, as we move along, do these amendments. And again, in a different line, Jairam has also said earlier, I expect, just as he said now too, I quote, I expect that in the months ahead, as we gain more experience in the implementation, We will continue this process of fine-tuning both of the IBC as well as the GST. End quote. So as we gain experience, it's going to be necessary for us to come up with amendments, such amendments which are going to be in response to the developments outside. Now, today's amendments, very quickly, I said there are 7. I would just tell you what is it that we're doing through these amendments. The salient features of these amendments are that we're bringing clarity on allowing comprehensive corporate restructuring schemes such as mergers, demergers, amalgamations, etc., as a part of the resolution plan. Many of you all did mention the resolution plan is something which is going to be determined and framed up by the Committee of Creditors, the COC. Government doesn't give it. Government is not giving the resolution. There is a Committee of Creditors for each of these issues, and they are the ones who decide it. So that's the first thing. We're bringing clarity to include these sort of parts in the resolution plan. Greater emphasis is being given on the need for a time-bound disposal at application stage. I'll, in a minute, give you the details of what kind of waiting list is there before us. It is now our duty. It's our duty as a House which had passed this code to also ensure that we don't clog up. I understand many of the members rightly said, the clogging up is not for anything else but for want of you appointing people. I can give you an answer for that also. I recall Honourable Member Kapil Sibal mentioning that. I have an answer to give for that too. Deadline for completion of the CIRP, which is the Corporate Insolvency Resolution Process, within an overall limit of 330 days, including litigation and other judicial processes. Votes of all financial creditors, which I'm glad very many of you all have picked up, for the scattered, dispersed creditors, some of whom now you can, every day you read, compare them with the home buyers. The home buyers now can have a voice in a separate voting process. They can vote, and their vote will be taken for what it's worth, and therefore they participate in the resolution process. That's being enabled now in the light of so many different issues which have come for the home buyers, which is a very serious issue. Many members even highlighted the quantum of money which is locked up because waiting for resolution. So this will move towards or help towards moving into a resolution situation. So votes of all the financial creditors covered under the section 21(6)(a) shall be cast in accordance with the decisions approved by the highest voting share, more than 50%, that is, of financial creditors on present and voting basis. The basis that we use there is being present and voting. The specific provision that financial creditors who have not voted in favor, this is a very important point, I want the House to take this into cognizance, the specific provision that the financial creditors who have not voted in favor of the resolution plan, do we forget them? No, we don't. Those who have not voted in favor of the resolution plan and the operational creditors shall receive at least the amount that would have been received by them if the amount to be distributed under the resolution plan had been distributed in accordance with Section 53. Many members did refer to 53, Section 53, and said, invoking Section 53, what will be the fallout? I'm here very clearly telling you that takes care of not everyone who's voted in favor, but even those who have chosen not to vote in favor, but they will be taken care of under the Section 53 of the Code. Or the amount that would have been received if the liquidation value of the corporate debtor had been distributed in accordance with Section 53. So Section 53 takes a full play there as regards those who have not voted. Inclusion of commercial consideration in the manner of distribution proposed in the resolution plan within the powers of the Committee of Creditors. That's another point which Jairam Ramesh brought out as a nugget. When a commercial decision for which the final word rests with the COC was treated not as a commercial decision, it really brought in a very big contention saying, is this going against the IBC's very spirit? And that's why in this amendment, in this speedily brought in amendment to the House, that is a very important point we've brought in. What is commercial shall remain commercial, and that cannot have a different dimension, and therefore that is a very important part of this set of amendments that we are bringing in now. Clarity that the resolution plan, shall be binding on all the stakeholders, including the central government. I'm glad many members, inclusive of Sri Alphonse, said central government shall also be a party to the resolution plan. You're bound by it, and that is something which this amendment brings in. And partly answering Jairam's questions, which I'll come a bit later to, but this, if it is binding on the central government, any state government also will be bound by this, and also local authorities, to whom a debt in respect of the payment of the dues may be owed. Clarity also is being brought in that the committee of creditors may take the decision to liquidate the corporate debtor any time after constitution of the committee of creditors and before preparation of information memorandum. Even then, the moment the committee of creditors is constituted, the motion sets pace. So that has to be very clearly laid before, and these are the changes, these are the amendments which we are bringing in. So the changes are expected to lead to a timely admission of applications. That's the most important point. Admission stage itself, the delays are worrying. So we are expecting to lead to a timely admission of applications and timely completion of the corporate insolvency resolution process. Analysis of data available demonstrates that there are delays in admission of applications and spillage of CARP cases well over the time limits which are permitted through the code. The amendments are expected to again address the issue of sanctity of timelines, of completion of the entire corporate insolvency process. So if these are the larger picture with which we are moving ahead, some of the specific issues which many of the members have raised, I'd like to answer them. I'll start with Sri Kapil Sibalji, who had raised, in fact identified and said, too many amendments are coming through, you're bringing in such amendments which may not be implementable, and so on. He broadly mentioned that 27 amendments have been already brought in. I just want to clarify, 27 is not correct. This is the third amendment to the IBC code. The first bill amended 8 clauses. The second bill amended 38 clauses. And the third one, now we are coming up with amendments to 8 clauses. So as on 30th June, 101 were withdrawn, the cases. 120 were resolved. 475 moved into liquidation. And of the 475, 349 were in the BIFR or were sick units. This point is being mentioned like in passing, but I want to underline that majority of the cases which are now being under the CIFR are a backlog, the legacy which has come from the BIFR stage. So if BIFR cases are also being dealt with now with a certain rapidity, it's because IBC is proving its worth, and what couldn't be achieved through the BIFR is actually being achieved now. And in that, I'd like to just give you some data. I recall some members were talking about behavioral change. Actually, I credit them for having used those expressions. Actually, there is a behavioral change which is happening for the good. And that should actually convince Sri Binay Vishwam that the whole objective is not to kill and finish off. We are actually coming up with resolutions which can help the unit to live its punarjanma, the next janma. So it's actually giving life, and that's where when Suresh Prabhuji's presentation, he said it's actually giving lives to company which are in almost ICU stage. We are not killing them off. We are giving more energy to them. We are infusing life into them. So I would want to link with this behavioral change point of view to one statistics I want to give before you. Details of disposed cases before admission even before admitting into the restructuring process, the CIPR, total number of companies or cases under Section 7, they were 894. Under Section 9, they were 5,102. Under Section 10, 83. A total of 6,079 cases. All of them get disposed of even before they get admitted into the process of resolution. What does that mean? It means people realize that if this comes into the effect, and it has come into effect, they have to go through this process. They may probably end up with a process of resolution, but in the process they may be out of owning their companies, or the resolution process would have its implication on their credibility, and therefore many of them have chosen to have a disposal mechanism through which they could get out clear. And what in terms of amount of money has this meant? 6,079 cases, all of them which got disposed of before admission. Somebody did mention, do you have a mechanism? What is the mechanism? This code doesn't. The amendment bill that you're bringing in doesn't speak of any mechanism. No, it does. That is why even before it sets rolling, people have come on their own to say, please, this is what we want to do, dispose our cases. That's the indication of an effective mechanism, not just a mechanism. And an effective mechanism of 6,079 cases getting disposed of before admission meant an amount of 2,84,000 crores being redressed, meaning that's the amount which has been used for settling claims. So if that is the kind of impact we are having because of a mechanism which is in play, before the mechanism sets rolling in a particular case, people have come to get their cases disposed of. Just shows how effective this whole process is. If that's the case that's the way in which much before the cases could come into resolution process, I gave you the data. I'll give you the data for those which have come into the process. As of 30/6/2019, 30th June 2019, 2,157 cases were admitted into corporate insolvency resolution process, the CIRP. Out of these cases, 164 cases were closed by appeal, review, or settlement. 112 cases were withdrawn under Section 12A. I think Sri Kapil Sibal had referred to 12A. 112 cases were withdrawn under Section 12A of the Code. Resolution plan was approved in 117 cases, and 474 cases have resulted into liquidation. In the total 117 resolved cases, an amount of 1,24,636 crores. 1,24,636 crores is realized. In some cases, it's realizable, if I can say, because some of them are almost at the fag end of the process. But 1,24,636 crores are realizable. And this is possible with having come into the CIRP. What earlier I gave you was before entering into it. Some more data points. As on date, 1,852 applications filed under Section 7 are pending admission beyond statutory period, the length of wait. Are pending admission beyond statutory period of 14 days, admission. And 5 big cases, some of which Sri Kapil Sibal named, SR, Amtech, Auto, Bhushan, Power and Steel, ERA Infra Engineering, and JP Infratech, and so on. Out of the 12 big accounts referred to IBC, these are pending for more than 600 days. Now, if we think that we can wait, we can't impose on the courts, 600 days. When I say courts, I also mean the tribunal, 600 days due to continuous litigation by some or the other party in the matter. So even the process is waiting because one litigation there, one other there, it's never getting started. So the emphasis, to emphasize on the intent of the legislature for time-bound resolution of matters, we've proposed to bring in the amendment to Section 7 and 12 of this code. a bit more data, because I think many of us were very keen to know about figures, saying what is this going to end up in. The status of the CIRPF. I've given till now what happens before, what happens just at the entry. Now the CIRPs, the Corporate Insolvency Resolution Process, under the code, as of 30th June, again, 30th June based data, I want to give you. The status of the CIRPS. Admitted number of cases, 2,162. Closed on appeal, which I read out about, 174. Closed by withdrawal under Section 12A, 101. I've given you slightly later data. Closed by resolution, 120. Closed by liquidation, 475. Ongoing, say, CIRP, 1,292. So, now the number of days waiting. The details on the ongoing CIRPs, along with the timelines, I'd like to mention here. Ongoing CIRPs are 1,292, the figure just now I gave you. Over 330 days, 335 cases. Over 270 days, 445 cases. Over 180 days, and less than 270 days, 221 cases. Over 90 days, but less than 180 days, 349 cases. Over 90 days, less than 90 days, 277 cases. The number of days pending includes time, if any, excluded by the tribunals. So that gives you a picture on what is the kind of weight, and therefore why do we want to bring the amendments for this speeding up. Most of the times we're talking about the cases which are pending. Of course, they will talk about what happens to creditors. They're waiting for eternity. Analysis of the 475, which I repeated twice, of the 475 CIRPs, which have yielded to liquidation. As of 30th June, 475, which have yielded for liquidation, claims of the financial creditors are 3,15,370 crores of rupees. Claims. Claims of the operational creditors, the risk was both of them are being treated equal and so on. But what are the claims? 31,285 crores. So the total claim is about 3,46,655. The liquidation value here is 24,117 crores only. So these are companies which had been in difficulty and under BIFR for years. Look at the change of profile once they're coming in for the liquidation process through the IBC. So that's what is more important to understand, that the IBC doesn't aim to delay or to just allow the asset value to fritter away, but on the contrary gives solutions where the optimization is possible of the assets. So the liquidation value is only 7% of the total admitted claims of these companies. Important because they're coming from the BIFR background. 73.42% of all these cases, I'm not going through that data totally, are BIFR cases or cases of those which are not anymore as going concerns, which means they're dead cases. 73.42 are in this category. There was this question, probably Sri Kapil Sibal raised, about the operational creditors and financial creditors. All financial creditors, he's an eminent lawyer. I'm not reading the book to him, but I still want to explain this point. All financial creditors form only one class, and they cannot be subclassified into secured or unsecured creditors for the purpose of distribution of monies under the resolution plan. That can't be. The NCLAT, the appellate tribunal, held that the distribution of monies under the resolution plan is not a commercial decision to be taken by the COC. Those are the 2 points on which we are coming up with a clear amendment so that grey area, it's not grey to me, but the grey area which has come up is being addressed.